to security and legal now. For those of you just joining, you're welcome. This is Hard Facts and 92.3 Nigeria Info. We're looking at the hard facts on this very issue. I am Kalanda Koribata, but once again, we're live on Facebook, Nigeria Info PH. We're live on YouTube, Nigeria Info PH. We're active on X, Nigeria Info PH. Now, last week, I think it was on Thursday, the news broke that the Chief Judge of Rivers State, Justice Simeon Amadi, had said that, or had gone ahead to give pardon to certain inmates, about 21 of them. They had been in custody in the prison, or is it the correctional facility, for not less than 6 years. I think there's one that was reported of staying there for about 18 years. And the reason why they were granted pardon was because, there was no charge sheets for them. They were there, no records. Some of them had no record. They were facing murder and kidnapping charges, but there was no proper record, and they had never gone to the court in those years they were in custody. Sad story. However, if you remember on Friday, while I was trying to have the conversation before the glitch happened, I remember narrating my thought in the manner that kidnapping and murder are no small charges, and if proper investigations were done or not, that's where my focus was. Because a few weeks ago, we had seen an individual who was pardoned and 1 week later caught in the act of robbery. I mean, he was just pardoned 1 week ago, and today caught in the act of robbery. And so that Friday, I said, should we not be focusing on whether these people did it or not? How do we reintegrate them back to society? Because it sounds very similar to the story in the northern part of the country where Boko Haram, they are rehabilitated and reintegrated into society. To help me have the conversation, he was so busy on Friday he couldn't join us, but now he's here. He goes by the name Living Jamala, is a Rivers-based lawyer, and he likes to analyze politics every now and then. It's good to have you in the studio. Welcome.
Good morning.
It's not morning. We're not on the morning show.
Good evening, Kalada. Good evening, Nigerian Info and the lovers of Nigerian Info.
It's been a while you came into our studios, right? It's been quite a while.
I think the last time you came on
Morning
as a
Prosper.
visiting. You came last visiting on Hard Facts.
Oh, okay. All right. I'm still visiting. My time expires on Monday. But let's get into the nitty-gritty. So to start the conversation, I'd like to understand what the law says, is punishment for someone who has committed murder and someone who perpetrated the act of kidnapping.
Before I will answer your question, Kalada, there are certain things that we should understand.
Okay.
Before delving into attempting to answer that question.
All right.
Now, the laws that govern criminal justice system in Nigeria is first the Constitution. I'm looking at the procedural laws. First, the Constitution, and secondly, the Administration of Criminal Justice Act of 2015. Now, that act has been domesticated by several states, including Rivers State. Aside other laws that are looking at the substantive law and the other aspect of it, these are the principal laws that regulates the administration of criminal justice law generally in Nigeria. Now, the Constitution establishes the office of the Chief Judge of a State, Section 275, my memory serves me right. Now, in that section, recognizes the office and the functions of
The Chief Judge. Yeah?
Now, there are subsidiary laws, especially since we're in Rivers State, let's deal with Rivers State. The Administration of Criminal Justice Law of Rivers State now gives even a magistrate to occasionally visit police stations, prisons, to see if there are some persons that have been detained or retained not in compliance with the provisions of that law or the Constitution. Now, I may not have this correctly, the law, but the chief judge of a state, the governor exercises what they call prerogative of mercy. The president have the power to occasionally, in exercise of those powers, visit one or two
correctional facilities or police stations.
Yes, to exercise those powers. So if you ask that, what my Lord, the Honorable Justice S.C. Amadi of Rivers State, the Chief Judge of Rivers State, whether that powers is vested in him, is squarely 100%.
Of course, I do know that part of the law.
100% vested in him.
Okay.
Now, how are the persons? How do they come about? Now, we are in Nigeria, and we know that there are sometimes, in fact, often, Nigerian security agents, especially the police, do what they can conduct mass arrests.
Yeah, true.
Where they arrest innocent persons. And sometimes, because those persons are unable to meet up what they call the conditions for bail, they are taken into a court, sometimes with frivolous charges that even the first court of instance, where it is handy for them to approach, and that is the magistrate court, will lack jurisdiction to entertain those proceedings, entertain the charges. And what becomes the fate of that person is remanded in prison. And most times when those persons are remanded in prison, because they're not interested in pursuing that case, those persons are sometimes abandoned.
Who's not interested? The police?
The police.
Okay.
The police is the chief prosecuting, subject to the powers of the Attorney General of the state or Attorney General of the Federation to either take over or discontinue a criminal proceedings. The police is the principal. The administration of criminal justice law in Rivers State gives an individual the power to bring before the court a private complaint. But there are some procedures you have to fulfill also. But the chief prosecuting officer, in respect to what we practice now, is the police. The police conduct the investigation. They make the recommendation to the legal department. And if the person, ordinarily, there is a prima facie case within their own understanding or within their own investigation that the person be charged to court, they do so. But because sometimes we as individuals also, we also procure the prosecution of our neighbors. Yes. Sometimes you see in land cases, purely civil matters. But because you want to show you have financial muscle above your neighbor, you bring in some professionals, or maybe you have some one or two police officers as friends. You write a petition that ordinarily should be a trespass, civil matters. You are inputting criminal elements into it. And sometimes they go about charging people for kidnapping when there was never a kidnapping attempt. They charge people for robbery when there was never
a robbery
an attempt. The essence, the ultimate aim of those persons is to dump those persons in prison, especially if you do not have one or two persons that can walk through the instrumentality of the law to secure your release.
So it means that this conversation is very timely, because a lot of people may not know, especially that young boy who was, I think, arrested when he was 14, while he was sleeping at the corridor of his home, and dumped at the Port Harcourt Correctional Facility for about 18 years. Exactly. And his family didn't know where. So in such a situation, what can the family do? Can the family sue the police, the Nigeria Police Force? Are they liable for such actions?
One of the rights that avail an accused person, a suspect in the circumstances, is the right to sue for malicious prosecution.
Okay.
Now, where you have been arrested on the person cannot justify unjustly, you have been not only arrested, prosecuted, to the extent that you have spent some reasonable number of days, reasonable number of hours, reasonable number of months, weeks in any of the correctional facilities, or even within, we're talking about trial now, in the correctional facilities, and you are found innocent. You can come back to institute malicious prosecution.
But there's a part in is it the Police Act that says reasonable suspicion? So if the police has reasonable suspicion against me, for instance, maybe the way I styled my hair, I'm looking like a cultist, or I'm looking like a Yahoo boy, and reasonable, and then they take me to court, but they have only 24. I'm sorry, they take me to police station, but they have only 24 hours. So you know what? They take me to court, remand me, and then forget me.
Let me shock you. In about 99% of the cases already pending in court, they are not being moved by the promptness of the Nigerian police, aside those who there is state interest. But it has to do on one or two, what they call it, achievement. Let me quote it, in the parlance of the prison yard. To achieve, it means that to steal. Now, those things are basically sponsored by individual. For you to move a prosecutor in any of the magistrate court to be so serious with your matter, you must be...
Okay, money must change hands.
You must be spending as though you retain that prosecutor to follow up a government matter, because criminal matters are state matters. And that is why they are kept there, paid on a monthly basis. But for him to have that interest, you must be doing something.
And he's prosecuting against you, by the way.
He's prosecuting against the defendant. Now, the nominal complainant is the one who is taking responsibility.
Okay,
to finance
I get you now. Yeah.
To finance that process. And so when that is done and you establish that you are innocent, you bring a suit against the nominal complainant, the one who facilitated the process, the one who used the instrumentality of the law to harass you in the circumstance. And even the police who arrested you with a reasonable suspicion is not about how I look. Reasonable suspicion is not about how I dress. Now, for you to have, like, assuming you are driving on the road, you are carrying a Lexus 330 white color car with a particular registration number, River State, for instance, and it is radioed in the central room of the Nigerian Police Force River State Command that there is a missing or a Lexus 330 white color car has been taken on God Point and is moving towards the east-west road. Now, for every police checkpoint that sees you coming with that white Camry car, there is reasonable suspicion to back you.
Oh, I get you now. So that's what reasonable suspicion means.
Yes, you cannot just see a car and say, please, can you stop? What is a reasonable suspicion? Is it a stolen vehicle?
I've got a commercial, Living Jamala, but when I come back, we'll talk about this and many more. Please do stay tuned.
Stay with us. Nigeria Info.
to inmates at the Port Harcourt Correctional Facility. That happened last week, and we're looking at it. We're looking at what the law says, what the law stipulates, if errors that may impact the state have been done, because we're talking security. Of course, you've seen these reports of court-related activities in certain parts of the state. I go by the name Kalada Korubataba. This is Hard Facts, and thank you for staying tuned. Welcome back, Living Jamala. It's good to have you.
Thank you, Kalada, for...
All right. So before the break, you were telling us about where did we stop? I think we were talking about how the police give
how they prefer
charges that are not legal, so
yes.
to say. And we're talking about reasonable suspicion, and you were talking about a white Lexus. If it was radioed to have been stolen at gunpoint, then that's reasonable suspicion, but not stopping any and every vehicle. So when the police stops a vehicle on the road, that's not reasonable suspicion.
In Nigeria, we've seen the police coming to do the work of road safety by asking for your papers. Now, ideally,
is that not
legally?
Yeah.
A policeman can only ask of your papers when there is reasonable suspicion that that car does not belong to you.
So how do we then know where there's reasonable suspicion from a civilian perspective?
That is not your responsibility. All you need to do at every material time that you are free from every suspicion as to the negative.
All right.
That is why you see a thief he may have succeeded in stealing somewhere, but moving around, maybe trying to find his way to his vehicle, and sees one or two security officers, he becomes apprehensive. And from the body language, those who study psychology generally, and because these policemen, they are trained or ought to be trained, you see them by mere meeting or looking at that person, they look at the body language and something tells them, please, can you search this person?
So back to our conversation before the break, I can sue the police for malicious prosecution, you say?
Fundamental human rights, yes, that is one of it. Then two, malicious prosecution, especially the nominal complainant. Especially for the police, you can sue them for fundamental human rights. For the nominal complainant who masterminded that process, he can bring malicious prosecution against that person and ask for damages.
So all the 21 persons who were pardoned, if it can be proved that they were maliciously prosecuted, they can all go to court and say the police should be held accountable.
If it can be proved that some of them were unreasonably, unlawfully kept for that period of time,
minimum of 6 years, by the way.
They can bring an action of fundamental human right against the Nigerian police.
Interesting. But to my very first question, what does the law? I know you said there are two types: the Constitution and then the criminal
administration of criminal justice law. I was trying to remember this very law before we went on break.
Yeah.
We has to do with Section 11 of the Prisons Act, Cap P29, Laws of the Federation 2024. 2004, sorry. That gives the powers to that Chief Justice of the Federation and the justices of the various states, yes, to exercise that prerogative.
But I was going to ask, what does the law say, most especially the one domesticated here in River State, the Administrative Criminal Law?
Administration of Criminal Justice,
I beg your pardon. What does it say about murder cases? What is the duration?
Murder cases, I talked about the procedural. Now you are taking me to the substantive law. Now, murder cases generally are what we classified into what we call the capital
offense.
Yeah. Now, capital offenses comes with capital punishment. For murder, generally, once found convicted by a court of law and so pronounced, is murder. You are to be sentenced to death.
Sentenced to death,
either by hanging or by facing the firing squad.
What about kidnapping?
Kidnapping, to the extent that it's still a capital offense, is life imprisonment. Cultism,
is
life imprisonment.
So these are heavy, like you say, capital offenses.
They are capital offenses that comes with capital punishment.
So can we do more. Now, you've just quoted the Constitution. The Chief Judge is backed by law
Yes.
to pardon people, to give clemency. But do you think pardon to such capital offences is allowed by the law?
You see, generally, bail, when it comes to capital offenses, the courts are somehow reluctant to grant bail.
Okay.
Looking at the nature of the offense, the prevalence of the offense in the society. But the courts have come out to develop another principle that we should not be afraid of that name murder alone. And therefore, generally believe that it is yes, it is heinous, but the person may not have committed.
So innocent until proven guilty.
That is a constitutional provision. That the general rule in every criminal matter, the general rule is that the Constitution has presumed that person facing criminal trial to be innocent until it is proven. Bearing that in mind, some persons may, a charge may or an information may have been preferred against them on murder, but they actually may not be the person who committed that offense.
What if they did? Now, armed robbery, I didn't get to ask, is armed robbery capital offense? So now, remember the story I told you about? A person released, pardoned for armed robbery charge, he was pardoned, and then caught. According to we don't know if it's true or not, we have to wait for the courts to tell us, but according to the report, was caught while committing armed robbery.
That is one of the negative side of the exercise of this power.
And I also remind you, sometime, was it after the election or just before the election, in MOA, there were pardons and the person went ahead to perpetrate some crime in MOA local government area.
Kalada.
At least that was the story we had.
That was the story we had. But yes, they exist. In reality, they actually exist. But have you also forgotten those who were pardoned and actually turned a new leaf and became useful to the society? That is the intendment of that particular rule, of that particular law. It's before these persons are recommended for pardon. It ordinarily, the officials of the correctional center ought to have studied them.
Underline that.
Yes, ought to have studied them and found them to be of good character. Some enter into the correctional center as hardened criminals. Come out. When they come out refined.
So you're saying there's the reformative ability of the correctional center. Does that exist? Because when we talk Boko Haram, a lot of people are afraid, you're reintegrating them back to society. It's similar to armed robbery, kidnapping.
The very nature of human being, the deceptive nature of human being cannot be excluded in the circumstances.
Okay.
You can bring someone to your house who all he's doing is just to get your attention of trust. And when that trust is given, when you least expect, the person strikes. Same with if you find our prisoners. Some will present themselves before the authorities that they have repented. In fact, you will see them in the chapel from morning till night, giving the impression that they have repented. But they are looking for something. Maybe a recommendation in the next visit. When the chief judge is coming, the authorities will look into his files. But remember, those who are facing criminal trial generally, when their cases are going, they find it difficult to enjoy this prerogative from any of the authorizing
the pardon, people with the ability to pardon.
Now, those who the chief judge Rivers State pardon, persons who ordinarily charges were preferred against them, but they were abandoned. No one is looking at that. There was no DPP report to the extent that yes, there is a prima facie case against this person, and therefore let an information be filed at the state high court.
Could they have been further investigation? Is there any legal framework that you know about that can track these people? Because in America, or as we see in the movies, let me not sound like I know very well, as we see in the movies, there's a system, probation officers that go around saying, what have you been doing? What have you been, where have you been? Where have you traveled to? The system tracks these people who were pardoned or who were recently released from prison? Do we even have such legal framework?
I think for that, I do not have the knowledge as to whether we have that existing system, but I'm aware, even from the statement of my Lord, the Chief Judge of Rivers State, integrating you into the community, go and be good ambassadors of the exercise. Go and show example that we're not making any mistake in releasing you. And if you do not have any source of livelihood, please relocate to
your village.
You can comfortably live your life. So to that extent, one can generally assume that we do not have that tracking system. It's not like an administrative bail where you are asked to report every 2 weeks or every 1 week. There is no condition attached to your release. But that notwithstanding, if tomorrow an investigation is continued and you are found to be somehow so close to the offense, that same charge can be brought against you. It does not. It is not.
Despite the pardon?
Yes. It does not preclude the state from prosecuting you. Now, the rule of double jeopardy does not come in the circumstance. Double jeopardy means you should not be tried. It's a constitutional right. You should not be tried for an offense that you are either been convicted or you've been acquitted.
But this one, you can.
It was never an acquittal.
Okay.
It was never a conviction.
So they can be called ex-convicts, I guess.
They are
No,
not
they're not ex-convicts.
To the extent that they have not been convicted, you can't call them ex-convicts.
Okay. All right.
You can only be called ex-convict when full trial has commenced, a judgment given, you're found guilty, and sentenced in the circumstance.
So spending 18 years in the correctional facility does not make you an ex-convict?
No, it doesn't.
All right.
You are just awaiting trial.
All right. We've got to go, you know the drill, commercials, we have to pay bills. But thank you very much. I feel like I've been educated just listening to you talk on this very issue. But I still have my concerns as it relates to, these people discharged back into society, because we never went to court to determine if they committed or did not commit, the case or the things that they were charged for. But thank you, Living Jamala. It's good to have you.
Thank you very much. But remember, even Jesus Christ, when he was selecting his 12, whether it was divine that he should have Judas in his team, but the Bible never revealed to us that Jesus knew that at that material time was being recruited that Judas would betray him.
All right. Okay. Thank you very much, Living Jamala. I see the phone lines are ringing. I'm sorry. 2 conversations I did not take.